See. Mr. LeBlanc,
Yes,
good morning.
Good morning.
Cause number 16079 on Cody Sandifer. Yeah, there they'll get them.
I hadn't seen you.
I know it's been a while. How you been?
Good, great. Orange is doing good.
All right, so you're Cody Standifer or Sandifer, I'm sorry. And I have a motion to revoke community supervision. What is the what's the announcement?
Judge, Philip and I have talked about this, and I know that it's been reset several times. There's a blood result waiting to come in.
Still?
Yeah, and Cody's been in for like, what, 6 months now? Thereabouts, over in Jefferson County. So we wanted to expedite things, but
I checked with intake this morning because it went to a DPS crime lab. So it's taken.
Okay. Well, I mean, all we can do is wait on that. If you want, I mean, if there's some agreement as far as a bond, I'll consider that. If not, then we would need a motion and we'll have a hearing on it.
on the bond,
Yeah, I mean, what's your position on that?
Well, my concern is the number of DWIs that he's had over the course of his life. This is like DWI number 7 or 8. He was on probation for DWI when he picked up a new DWI. I understand there were some extenuating circumstances, some trauma or something in his life and relationship, but I would be opposed to a bond at this point, Judge.
Okay, so what I would do then, Mr. LeBlanc, if you want me to consider have a hearing on a bond, file a motion, we'll get it set for that. Otherwise, we will, we can do a couple things. You can go ahead and enter pleas of true or not true to the motion. We can get it set for a hearing and then see where we are as far as, I mean, obviously, the level of proof. I know y'all want the new case, but on the MTRP, the level of proof is different. You can bring the officers, we can have a hearing, you know, without the blood work or.
Can we reset it one more time and then do the plea if we don't have the results at that time, Judge?
Yeah, if everybody's okay with
we're in
that.
agreement.
Okay, this will be it. After that, we need to do something on it.
I understand.
Yeah, okay, thanks. All right, you can go back with the bailiff.
And that's 30 days, Judge?
Yes,
Okay.
approximately.
Approximately. Okay. All right, Cody.
Mr. Macon on Ray Jones Jr., cause number 23 DCCR 0151.
Yeah, sure. I still have a bunch of subpoenas out.
Hang on just a second. Let's get everybody up here. Good morning. Ray Jones Jr. Morning.
I don't know if she's
You mentioned
that's what's making that noise.
I don't know that I should have anybody on bond. This is my jail day, so I don't know
I'll go find out.
if she has a case somewhere. Melissa Wilson. Would you look that up to see where she's supposed to be? No, you're fine. Thank you. All right, sir, are you Ray Jones?
Yes, ma'am.
And Mr. Jones is charged with harassment of a public servant. What's the announcement?
Your Honor, I've issued several subpoenas for a bunch of records. And I don't have the videos yet. And once I get those, I'll get with Mr. Jones. I've been in talking with Tommy. And once I get those and go with Mr. Jones, I think we may be able to work something out. But at this time, Mr. Jones is adamant that he wants to try.
Okay. But you don't have everything as
No,
far
I
as
don't.
discovery yet.
No, Your
Do you know where it is in the process of getting the videos? I feel like this is a broken record. Yeah.
Judge, I'll be happy to direct you after the document.
Okay. Yeah. If you'll just double check, make sure that the request was made. And if there's some issue with the request, Mr. Macon, make sure you get that done again if you have or haven't.
We
And,
requested it on July 14th.
okay.
And it looks like there is a note in this file from Karen in her office. She makes her own little initials and note.
Well, that was July 14th was just a week or so ago. So that's just been requested.
Yeah.
She's made it. With my notes in file, looks like it's been made available. Picked up.
We'll work on that.
Okay, I need to make sure you get that taken care of. I want this to be the last reset for an announcement.
Sure.
And then we'll move forward with either a plea or moving it to the trial docket after that. All right, you can go back with the bailiff.
Have excuse, Your Honor.
Yes, sir. Thank you.
Thank you very much.
Mr. Matuska, Jalen Nixon, 3 cases. Jalen Nixon. Mr. Coleman's.
I'm actually in.
What you were looking a little different, kind of little.
You might say I have big shoes to fill.
Right, you're Jalen Nixon, and Mr. Nixon has 3 cases, 2 aggravated assault on a peace officer's 1st-degree felonies, and then a 3rd-degree felony offense of obstruction or retaliation. Mr. Matuska, what is the announcement?
I provided one USB. There was multiple USBs in this case. I spoke to Karen yesterday about her getting those together. She told me that she thought next week, but I learned last night she worked really hard to get them. So I think they're available today.
Oh, okay.
And so I'll have that. I just need one more reset.
Okay,
Quick
perfect.
reset would be fine.
Well, good. Tell her thank you for getting that done. We'll do one more reset. Mr. Nixon, I'm sure Mr. Matuska will be out there with all that information so that you guys can make an decision on what you want to do with your case before that next court date. All right, you can go back with the bailiff. Ms. Perazzo, cause number 40181 on Kaylin Johnson.
Yes, Your Honor, that's going to be a plea.
I'll hold it while you get that taken care of. See, is Brittany? Let's see, Brittany. Okay. And we have Mr. Kelly, Tom. Mr. Lewis on Daniel Leatherwood, cause number 23 DCCR 0601. Hold them.
Mr. Coleman, is it possible off the record for a second?
And Mr. Lewis, you have Ian Meadors, cause number 35142. I do not. What was the PSI says 2-year state jail cap. Obviously, that's not correct.
It was a 2-year TDC.
2-year TDC cap.
He wanted to make the argument to see if he would keep it probation.
Okay, all right, you're Ian Meadows.
Yes, ma'am.
And Mr. Meadows was previously in court, entered pleas of true to counts 1 through 4, and a motion to revoke unadjudicated probation, was placed on probation January 25th of 2021 for unlawful possession of a weapon on a licensed liquor licensed premises. That was a 3-year deferred probation. I've received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Go ahead, Judge.
Yes, sir.
Excuse me. Any additions or corrections?
No, Judge, not from the state.
And it's my understanding the agreement was either for me to continue probation, or it was agreed that it would be capped at the minimum, which is 2 years. Is that correct?
That's correct.
All right, Mr. Lewis, you may proceed.
Judge, of course, this was a situation that Mr. Metters was placed on probation back in 2021. At that time, he was in a very unstable situation. When he got back home to Louisiana for his transportation, living environment, no job at that point. And it took him from January when he got home until October of that year to find stable employment. He had to move, he was able to find himself somewhere to live, a vehicle, everything at that point to really get himself going in the right direction. Unfortunately, at that time, I believe the warrant had already been out on him, or he definitely was under the impression that at that point, the warrant was out on him. And it was just a situation of that fear, I think, is what caused him not to turn himself in or come on in at that point and take care of it. Since October of 21, he's been working with R&R Cassidy, even worked himself up to the foreman of approval, about 6 to 8 people on jobs. He does have a 8-year son who I think just turned 8 on the 15th, and he's autistic. So he's the main breadwinner to take care of him and get him situated. And at this point, he's been in custody now, I believe, almost 4 months. His job is still there, waiting on him. That he's got that type of trust with his employer, the way he can come back and still work. His fiance, I believe, is still has been able to maintain the home situation until he can get back. So he's not in the same position he was when he first got probation. And he didn't realize that the situation was that unstable until after he got back home to Louisiana, because he was here working at the time when he picked up his offense and got the probation. And then when he got back home, that's when, he realized just how bad of a situation was, given the responsibilities he had with probation. And by the time he was able to get it situated, of course, he was in this, in a situation with this motion. So Judge, he is asking if it's possible that he can be continued on probation, even with an extension or something, or even amendment of his conditions. I was explaining to him that those are things that are possible, not just, so it could not just be so we just go home and keep going. It still could be other amendments that could be made to his probation if allowed to continue on, that he would have to deal with those as well as the other obligations. He's at a point now, I think, that he understands he can't run from the situation at all. So we are asking, Judge, that given that he doesn't really have a criminal history, to my understanding, even from out of state, and he just was unfortunately was in a real bad situation when he did get out from doing that 10 days up front and getting back home. So we are asking that he be allowed to continue on probation and possibly complete successful.
Mr. Smith, what's your position?
Judge, in this case, it looks like the defendant, when he got out of jail, I know he would have been instructed to report to the probation officer, to the probation office, the first thing he did when he got out of jail. I understand that those instructions are very clear when they're given to him. He never reported for intake. He left this state without permission to be in Louisiana, which, had he gone to probation to obtain that permission and given him the information that he had, they could have helped him. He chose not to do that. He chose to do things on his own, but violated the interstate compact by doing that. I don't know that Louisiana would even accept him at this point, since he has been in their custody or within their jurisdiction and unreported. So I think that TDC would be the best option in this case. We defer to you.
And Judge, if I may, one quick thing, just to kind of point to the situation when he first was released and was to go to intake. That's a prime example of how unstable the situation was, because he was able, someone picked him up from his home, a family member, his
She
mother,
rented a vehicle.
rented a vehicle, took him back home to Louisiana, but then I think that was like on a weekend.
It was.
And then have the transportation wasn't available to come back the following Monday to get things started for us to transfer. And it kind of just steamrolled from there. And
All right, so here's the thing, Mr. Metters. I mean, you have one misdemeanor and nothing else in your criminal history. You're 6 years old now, 7 now? You don't, in my opinion, you don't belong in prison. But you didn't, I mean, you could have gone to prison for 10 years for not doing this probation. And it doesn't matter if I give you this opportunity and keep you on probation. At this point, the circumstances, and Mr. Lewis has done a great job of giving me all the information, and I understand and can empathize somewhat with what's going on, but you got to get on the bus and get here. You got to, I mean, it doesn't matter. Those things will not be able to be used as an excuse ever again if I continue you on this probation. Do you understand?
Yes, ma'am.
There's going to be some very specific requirements. And it's really also going to, where you are allowed to live is going to completely depend on whether or not Louisiana will take you back. If-
Probation,
Yeah, right. Courtesy supervising you.
so I might have to come back here for reporting and stuff.
You may have to live here. It's that simple. If they don't take you for courtesy supervision, you're not going to go live somewhere else and come back here. Probation will work that out, but you've got to go through the right process and follow all of the rules. They may, I'm not saying that they won't, but there's a process that you have to follow. Honestly, probably with the amount of time, 2 years in PDC would probably be the easier thing, because I'm going to extend your probation, but you're not going to have a felony conviction on your record. And a felony conviction on your records would change your life very negatively. So, I mean, if you're asking me to continue you on probation, I'm willing to do that. It's not going to be the 3 years that you've already been on, because that's almost over, right? So what I'm going to do is find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to extend your probation for a period of 2 years, and you will be on what's called zero tolerance. It means you can't make any mistakes. You've got to do it all right. Otherwise, they're going to let me know you're going to be right back in jail on a motion to revoke your probation. You are not allowed to leave Jefferson County until you have permission from probation to go back. So until, it doesn't matter if you're released on a weekend, on a night, it doesn't matter. You're going to stay in Jefferson County until you have that appointment with probation and they tell you, okay, you can go, and this is the paperwork and what you have to do. You are not allowed to leave. If you do, it is a violation of your probation. Do you understand? Right. So, I mean, you still have every opportunity to keep this off your record. I hope you take advantage of it. I hope you take care of yourself and your family, but just keep in mind that there aren't going to be any excuses this time. Okay.
Yes, ma'am.
I'm handing you the trial court certification, shows this was an agreement that I followed. And so you've waived any right to appeal. Probation will talk to you before you leave today, but the main thing they're going to tell you, and I'll tell you this again, is the first thing you do when you're released from custody is go to the probation office. That's if you mess up that, then there's nothing else after that other than coming back in front of me and looking at 2 to 10 years in prison. All right.
Thank you so much.
All right. You're welcome. You can go back with the bailiff.
thanks. Sir.
Thank you.
See. Mr. Rojas on Wyatt Hammer, clause numbers 23 DCCR 0578 and 0579. Has it? Wyatt Hammer. Do we know, did somebody?
thought he was. Okay, I guess he's not recent.
You are Wyatt Hammer?
Yes, ma'am.
Okay, so it's my understanding that everyone needs some more time. Is there something?
I'm waiting on a case from.
Okay, any expectation of when that's,
I'm not real sure. The detective, I know is in the middle of investigating and I believe the victim's been interviewed. Hopefully he's getting all that together. He submitted some additional information on the two cases we do have on Friday that I haven't yet gotten into discovery yet.
all right. So obviously you'll need to get that, Mr. Rojas, once she has it. And then we'll wait and see. Let's just do, we'll just do normal 30 days and see where we are at that point. We're going to reset your case, Mr. Hammer. I'm sure Mr. Rojas will be out there to let you know what all's going on. You can go back to the bailiff. And on Walter Sims, cause number 39422. Did you talk to him about mine? Just something different. I just think. Yeah.
I agree. I don't think it'll blow it up.
Sir, are you Walter Sims? And will your client waive the formal reading of the motion?
He will.
Mr. Sims, I have before me a first amended motion to revoke your community supervision or to revoke your unadjudicated probation, excuse me. It shows that you were placed on probation June 15th of 2022 for the offense of deadly conduct. That was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of unlawfully carrying a weapon February 28th of 2024 in Jefferson County. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of marijuana February 28th of 2023 in Jefferson County, Texas. True or not true?
True.
Count 3 alleges that you failed to report as directed to the probation department February 22nd of 2023. Is that true or not true? Count 4 alleges that you possessed a drug, marijuana.
Excuse me, Your Honor, I'm sorry to interrupt. We can skip 4 and 5. I would like one last plea of true to 6, and then that should be enough since we haven't agreed.
Right, state abandons 4 and 5. Count 6 alleges that you committed the new offense of evading arrest or detention June 5th of 2023. And is that true or not true?
True.
I guess we also need.
What's the status of the other ones?
I don't think I think the misdemeanors have been filed. Correct me if I'm wrong, please. I don't think that number 8, the felony drug charge, has been filed.
Count 7 alleges that you committed the offense of failure to identify a fugitive or give false information June 5th of 2023. Is that true or not true?
True.
Count 8 alleges that you committed the offense of possession of a controlled substance, penalty group 1, June 5th of 2023 in Jefferson County. And is that true or not true?
True.
And 9 is duplicative, Your Honor.
All right.
And 10 also.
State abandons 9 and 10 as well.
Yes, sir.
Did you enter your pleas of true to counts 1, 2, 3, 6, 7, and 8 freely and voluntarily?
Yes, ma'am.
And because they're actually true.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Just a second. I'm not real sure I love this. What about the cases in Galveston County from the original motion to revoke?
I don't know the status of those, Judge.
Huh? You don't have a violation of a protective order and continuous violence of family in Galveston County? Were you arrested for those? That's just made up stuff?
I mean, I ain't ever been listening to God.
I mean, this is from November 30th of 2022. That's the wrong. It's, no, because that's a different defendant. All right, never mind. Okay, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 6, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of deadly conduct and sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived any right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. All right, good luck to you, sir. You can go back with the bailiff.
Feel better about not knowing anything about those.
Cause number 33214 is called on Jose Hernandez. Mr. Parker. It just made it all look a lot worse when I was like. What happened? It's been in there a long time. Oh, March 9th, 3 days after. Because it was kind of the same type of offenses. I'm thinking, absolutely not. His face, I've never been ghost.
You don't have to believe it or not.
I know. I mean, he looks pretty serious about it. All right, sir, you're Jose Hernandez. And will your client waive the formal reading of the motion? Mr. Hernandez, in cause number 33214, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation November 7th of 2022 for burglary of a building, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
Motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft March 1st of 2023 in Jefferson County. And is that true or not true?
Yes, ma'am.
Is it true or not
Yes,
true? Count two alleges that you failed to provide verification of performing the community services required. Is that true or not true?
Yes, ma'am.
Count three alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count four alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true?
True.
And then count five,
We can ban the count five.
state abandons five. Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
What is the status of that theft case?
What's going on with your theft case? Have you put out on that yet? You need to take care of it, I guess.
I need to know the status. Yeah. You can't go if it's pending, so I need to know that that's going to get taken care of before I follow the agreement. What is that set on over there? It's set on 68, but it's 73 in here.
The chiller went out last night.
Yeah.
I got it fixed, but it's.
I feel it. but- Is there a way for y'all to tell where his theft case is set and which court and
Where is it?
Set for today.
okay. Thank you, Deputy Milhouse.
You're just a wealth of knowledge, isn't you?
Well, glad somebody is.
Yeah.
So, Mr. Hernandez, I want to make sure your intention, it sounds like on that theft case, your intention is to go down today to misdemeanor court and you're going to enter a plea of guilty and work out some arrangement on that. Is that correct?
Yes.
Okay. I mean, my concern is that he's on for burglary of a building. He's committed a new theft. How long have you been in jail on the motion to revoke? This time?
This time. Been a week or 2 weeks, month, 2 weeks, more than a week.
I mean, so the agreement that you've reached is for me to send you to ISF. So that is hopefully to encourage you to make some better decisions and give you some tools to make better decisions. But you got to quit stealing or you're going to go to prison. It's just that simple.
Yes, ma'am.
Were you what happened with ICE? Do you have an ICE hold on you?
No.
You did at some point, right?
Yeah, back then. So.
Right. And so what happened?
Well, I got deported.
Okay. So you're not here legally, correct?
Yes, ma'am.
You're not in the United States legally?
No.
Okay. No, I'm not gonna take this. That makes no sense.
All right.
All right, y'all can, I will, I'll keep the pleas of true for now. If y'all want to make some other agreement, but I'm absolutely not going to accept a deal for him to continue on probation. He's not here legally committing more and more offenses. Nope. I'm gonna delete the paperwork. Y'all can reevaluate that, or we'll go unagreed if that's the case. I don't know. I'm not sure I'm understanding.
I don't have any idea.
I don't know if he actually was sent away and got back, but there's still a hold. If there's still
So
a
he probably
hold.
did.
So maybe they did
Yeah.
the proceed. You can ask him. I don't know if he went anyway,
I don't have any idea about this.
yeah. All right, I'll hold that. Let's
Okay.
see, clause number 23, DCCR 0272 on Corey Thomas. Did Ms. Palazzo do paperwork on time? It does show that they released it in March. Okay. All right. So are you Corey Thomas? Pull your mask down a little bit so I can hear you better, please. All right. Are you sick? Go ahead and pull it back up if you're sick. And will your client waive the formal reading of the indictment? And we're going on just one, the count two, I guess.
Yes.
Mr. Thomas, the state selected to proceed on counts 1 and 2 in 23 DCCR 0272. You're charged with the second-degree felony offense of indecency with a child by sexual contact from December 22nd of 2022. The indictment alleges you were previously convicted of robbery, a second-degree felony, September 23rd of 2002. And how do you plead to that charge? And is that prior offense true?
Yes.
Are you entering your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? I'm sorry.
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Any evidence that Mr. Thomas is not
There you
competent?
go.
Right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of indecency with a child by sexual contact. Also find that prior offense true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Parker. Also, we need a sex offender registration admonishment. If you get that done before you leave, I want to make sure you understand, based on your plea, that you will be required to register as a sex offender. Do you understand that? And Mr. Parker is going to go through a different document with you that I'll need your signature on that explains all of that to you. So y'all can take care of that real quick as well. There's one on the tablet. There's also, we can get you and use the tablets, probably easier, better, please. Mr. Kelly, did I see Tom? I thought I did. Mr. Parker, on Rachel Garrett, clause number 41454.
She's in the back. We need a reset on that for a couple of weeks. I don't know if you want to run around or not, but I've talked to her. You lowered her bond last time to give her a chance to bond out. Her dad died. Her mom's trying to raise the money to get her out. There's some issues about a cell phone that they've ordered that we were supposed to provide documents to them, and her mom's ordered it and she's having trouble, but she asked if we could have a couple more weeks for her to get that to provide, and I've talked.
The long and short of it, Judge, the state's not opposed to a reset.
So what I'll do, I'm just going to do a normal reset.
Fine.
If something happens and you guys work something out ahead of time, just let me know. We can always move it up.
Thank you, Judge. Joshua Perry, please go through it.
Cause number 30419 on Joshua Perry.
This is when we had paperwork last time, and then he changed his mind.
So it's just unagreed.
Yes.
Okay,
I mean, I don't know if he may plead true to me.
okay. That's right. We'll go through all of them. Good morning. Are you Joshua Perry? And Mr. Perry, would you please, the best you can, raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. And Mr. Parker, will your client waive the formal reading of the motion? Mr. Perry, I have before me a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation April 22nd of 2019 for the offensive burglary of a building, and that was a 3-year deferred probation. Is that correct? It alleges that you violated your probation. One alleges that you failed to report as directed to the probation department January 15th, March 10th, and April 29th of 2021. And is that true or not true? True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Just, so here's the thing, we're gonna go through the motion, get pleas of true or not true. And then I'll reset it for a sentencing hearing where you'll be able to explain. You can talk to Mr. Parker. He'll present information. Probation is going to do an updated report. So today I just need the pleas of true or not true. If there's explanations, we'll get those later. Okay. So is count 2 true or not true? Okay. Count 3 alleges that you failed to immediately report to the probation officer your lack of a phone number. Is that true or not true? Mhm.
True or not?
Just true or not true? Count, did you say true? Count 4 alleges that you provided a urine sample January 15th of 2021 that tested positive for methamphetamines, amphetamines, ecstasy, and tetrahydrocannabinol. And is that true or not true? Count 5 alleges that you provided a urine sample March 30th of 2021 that tested positive for methamphetamines, ecstasy, and tetrahydrocannabinol. And is that true or not true? Count 6 alleges that you provided a urine sample April 12th of 2021 that tested positive for methamphetamines, amphetamines, and tetrahydrocannabinol. And is that true or not true? Count 7 alleges that you provided a urine sample April 26th of 2021 that tested positive for methamphetamines and tetrahydrocannabinol. True or not true? Count 8 alleges that you failed to provide verification of performing the community service as required. Is that true or not true? Mhm. Okay, then not true. It's just true or not true. Count 9 alleges that as of April 29th of 2021, you were behind in your court assessed fees in the amount of $2,205. Is that true or not true? Count 10 alleges that you failed to report to the probation department as directed April 26th of 2021. Is that true or not true?
True.
Count 11 alleges that you failed to remain in Jefferson County, Texas as ordered, and that you were in the state of Georgia at the time of your arrest without permission. And is that true or not true? And count 12 alleges that as of May 30th of 2023, you were behind in your fees. I guess they've added up since then in the amount of $3,624. Is that true or not true? Did you enter your pleas of true to counts 1? Hold on a second. And then 3 through 7 and 9 through 12 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. But what I'm going to do is reset your case so that we can do a couple of things. One, we'll get an updated pre-sentence report from the probation department to let me know more about what's been going on with you and your probation. Anything that you think is important for me to know, get that information to Mr. Parker. He will present it to me on your behalf when you come back, and then I will decide at sentencing what to do. All right, you can go back with the bailiff. Yes, ma'am. Clause number 40181 on Kaylin Johnson. Razzo,
Razzo,
hold it. Mr. Kelly,
Yes.
clause number 40827 on Michael Miller.
Good morning.
Good morning. Good morning. Are you Michael Miller? And Mr. Miller's charged with the second-degree felony offense of intoxication manslaughter from July 9th of 2022. Mr. Kelly, what is the next announcement?
Judge, I don't know if you could see over the bench, but you might be able to tell by Mr. Coleman's binder that we've still got some discovery to get through. So we'd like to ask for another announcement.
So that's why on this reset, I'm not being smarty, but I reset it 60 days last time, knowing that. And I said, if you need a reset prior to the next setting, please let us know a couple of weeks ahead of time so that we don't have to transport him over to court, because that's an issue. So
Then the only thing I can do is say I missed the note and apologize to the court.
So just let us know ahead of time. Obviously, it's a lot of information. I'm willing to work with you guys on that. Another 60 days is, I'm going to do that. I need y'all to see where you can
I
get
think we
and
would
try to
make
get an announcement.
on that day, Judge.
All right. Okay.
If the court would allow us, Michael's almost done. The federal sentence that's kind of connected to this case. Our understanding is that a bond hasn't been set in this case yet. So I'd like to ask that a bond be set. If the court isn't inclined to do it just on request, I'm happy to file a motion, but because he's been in federal custody. for
There was a
about year.
$250,000 bond set by Judge, it looks like Templeton, at magistration at the jail on, I can't tell the date, though. I can't read it. So
It
there's.
was in June of last year. Okay, I don't know what our confusion was then, because I know we had checked.
I mean, unless if it's, ma'am.
That's right. Wait,
What happened?
I think that when he was arraigned, it's possible that he wasn't arraigned on both cases while in state custody. He's then transferred to federal custody on possession of a firearm by a prohibited person.
Mhm.
And is completing a 13-month federal sentence right now. It's almost over, it should be over next month. And has recently been brought back to state custody.
So we need to make sure on that. I mean, he was arraigned July 10th of last year by Judge Templeton, who it looks like specifically said on number one, I'm looking at the magistration sheet, intoxication manslaughter, 250,000 with interlock device and a GPS. And so I want to make sure that whatever we have to do to make sure that's in the system, because that's already done. So that should be the bond that's set. We'll make sure whatever happened, that is in there if something happened anyway. So there will be a bond set of 250,000. And then obviously if you want some type of hearing on a reduction or something like that, then you can file a motion and we'll get that set for a hearing. Otherwise, I'm going to reset it 60 days. Thank you.
Thank you, Jim.
Okay, can we get that? Who needs? Yeah, for sure.
And
Because if he finishes, as soon as it's finished, it's not gonna have, they're gonna let him go. So we need to make sure and get that done ASAP. Whoever needs the jail or. Ms. Prazo, cause number 40181 on Kaylin Johnson. Good morning. Got your discovery certification. Thank you. Oh, yeah. All right, sir, you Kaylin Johnson? And Ms. Prazo, will your client waive the formal reading of the indictment? Mr. Johnson, in cause number 40181, you're charged with the first-degree felony offense of murder from March 27th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? I mean, either you did it or you didn't do it. You didn't do it? Okay, then we'll set it for trial. You don't get to plead guilty and also tell me that you didn't do it. So let me tell you, hang on a second. Mr. Johnson, a minute ago, you were over in front of my clerk, right? And you raised your hand and you swore that you were going to tell the truth. So right now, if you're not telling me the truth, you're committing another felony offense. So either you committed the offense of murder or you did not. Did you? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazo? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? So you can't change your mind tomorrow and say, I didn't really do it. I want to take this all back, right? You understand? You also understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1. It's admitted. Any evidence that Mr. Johnson's not competent? All right, Mr. Johnson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the first-degree felony offense of murder. Sentence you in accordance with your agreement to a term of 25 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. Mr. Coleman?
If I could just put something on the record.
Yes, sir.
The state has visited with a couple of the family members of the victim. We've communicated the state's offer along with the rationale for making the offer and the realities of surrounding and the circumstances surrounding this defendant and posture of this case. Just want to make sure we put it on the record.
And Your
Thank you,
Honor,
Mr. Coleman.
There
Yes,
was one
ma'am.
thing I would like to have on the record as well. As far as any back time that Mr. Johnson is entitled to, would it also include his time that he was behind bars in the juvenile system?
Yeah, so we get that information, right? If it's because it was this case, we'll get that.
Okay.
Yeah, so
He was certified as an adult.
He
correct?
was.
And Judge, the state would not be opposed to
the
that.
time prior to the certification, we'll make sure that they get that information from the juvenile center and that will go along with it.
Perfect.
All right, you can go back with the bailiff. Good luck to you. Thank you, Mr. Coleman, Ms. Parazo. Let's see, calls number 33214 is recalled on Jose Hernandez.
I said, so you give me murder for 25 years, and my guy who's still 2 years, I have some guy, so you give him 18 years. He said, my guy's been a long time. You know. Man. I need to go home. Judge is saying you need to try.
Well, you probably have a point.
Mr. Hernandez, right here.
Okay, again, you're Jose Hernandez. And it's my understanding that there is a different agreement that you guys have reached. Is that correct?
Yes, Judge.
And so I had deleted the paperwork, but I did not recall everything we did. The previous pleas of true were made to counts 1 through 4, correct?
Correct.
No change on that.
No change.
All right, so
And 5 was abandoned.
Mr. Hernandez, I'm just going to go back and make sure in cause number 33214 that you entered your pleas of true to counts 1 through 4 freely and voluntarily. And because those counts are actually true. And so I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand if I follow this agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Any evidence Mr. Hernandez is not competent?
No, Your Honor.
Sir, can you keep it down over there, please? You've been asked several times to kind of keep it down. All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk to Mr. Parker. Good luck to you, sir. You can go back with the bailiff. See, Ms. Holmes, you're working on yours. All right, you're what we've got left. So just let me know when you're ready. Court will be in recess until then. We haven't- we should have done that before the trial anyway. Let's see, cause number 39566 is called on John Rice, Mr. Lane and Mr. Rice.
Yes.
So obviously, we are here this morning. We're supposed to be starting back at trial this afternoon or to begin trial. We've got a jury selected. Mr. Rice, it's my understanding that you have changed your mind and want to enter a plea of guilty and have a plea agreement. Is that correct? And you know, we've already picked a jury. We're ready to go this afternoon on trial. If we go forward with this, you will be waiving and giving up that right. You understand? And is that what you want to do?
Yes, ma'am.
Will your client waive the formal reading of the indictment?
He will, Your Honor.
And we're going on count one only.
Yes, Your
Mr. Rice, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of aggravated assault from March 1st of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal.
Yes, ma'am.
And the agreement that I see here is that you've reached is for a cap of 12 years in the institutional division of the Texas Department of Corrections. And what that means is that if I follow the agreement, I cannot give you more than 12 years in prison. I can give you 12 years. I can give you less. What'll happen is I'm going to ask the probation department to do a pre-sentence report. That'll give me more information about you and your case. We'll come back at a later date for sentencing. Mr. Lane and Mr. Nichols will both be able to put on any evidence that they want with regard to sentencing, and then I will make my mind up on that day. Do you understand?
Yes, ma'am.
And is that what you want me to do?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Rice is not competent?
No evidence, Your Honor.
And so, Mr. Rice, I am going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. You understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to reset your case for sentencing. And then we will come back. You'll need to talk to probation before you leave the courtroom. She's sitting at that desk right over there. But give me just a second. Let's see.
Your
You're-
Honor, there was one comment. Yeah.
Okay, you, you made $150,000 bond, right?
Yes,
Okay,
And Your Honor, as far as I'm not aware of any violations of his bond conditions.
okay.
As long as he maintains that, no problem.
All right, Mr. Lane, did you have something?
I was just going to, the court had made, I guess, a statement that the range of punishment could be anywhere from 2 to 12 based on the plea. I believe that probation deferred was actually a possibility.
It is. I mean, there's, yes,
I
straight
think-
probation or deferred probation, I believe would probably be a
I
possibility
believe so from the court judge.
from the court, not from the jury, but from the court. But I mean, that is, yeah, some type of probation is a possibility depending on the evidence that's presented to me when we come back.
Yes, sir.
All right. Anything else then?
No.
All right, Mr. Rice, just make sure you stop and talk to probation. And I want to make sure you understand a couple of things between now and sentencing. The first thing is that if you don't go to the probation department and get this pre-sentence report done and the interview process done, then you run the risk of me not accepting this plea agreement. Things could be much worse. We'll get another jury. We'll get started. Do you understand? The next thing is that if you are arrested for anything between now and when we come back for sentencing, you also run the risk of me not accepting this plea agreement. Do you understand? All right, we'll see you back at sentencing. Stop and talk to probation.
Yeah.
Thank you. Ms. Holmes, are you ready?
On Spooner,
You're still working on some?
just, this is Mr. Kane,
Okay,
but I have, other paperwork ready on this.
we'll
Spooner.
finish that one.
Okay.
All right, cause number 23, DCCR 0496 on Herbert Kane. Mr. Kane? All right, so right there, are you Herbert Kane? And will your client waive the formal reading of the indictment? Mr. Kane, you're charged with the third-degree felony offense of obstruction or retaliation from April 14th of 2020.
Judge, we'll proceed on the lesser included.
Gotta write that on the first page. Let's do direct class A. Gotta write that, all of it in. To class A.
Yes, ma'am.
So it's lesser included terroristic threat
Gotcha.
on a public servant.
Okay. The state has elected to proceed on the lesser included offense of a class A misdemeanor terroristic threat on a public servant and from April 14th of 2023. How do you plead to that charge? Are you pleading no contest freely and voluntarily? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
Any evidence Mr. Kane is not competent?
No, Your Honor.
All right, sir, I'm going to find,
Because since he tendered
oh,
no
yes.
contest plea, that we have to offer a state's exhibit 2, which is a probable cause affidavit.
Thank you, Mr. Smith. Any objection to states 2?
No, Your Honor.
All right, then based on the state's exhibit number 2, as well as the information in the admonishments, I am going to find, and there's no evidence he's
No, Your Honor.
competent. All right, so I'm going to find then, based on all of the evidence, that you are mentally competent, that you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the Class A misdemeanor terroristic threat on a public servant. Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you have waived any right to appeal. Good luck to you, sir. You can go back with the bailiff. That goes in the file, right? We decided. Cause numbers 27651, 26858, 23 DCCR 0520, 0521, and 0522 are called on LaWanda Spooner. You're gonna have all your.
Yes, ma'am. Let you know.
All right, you're LaWanda Spooner. Your client waived the formal reading of the indictments and the motions in each case.
Yes, Your Honor.
Ms. Spooner, in cause number 23, DCCR 0522. We're going on count 1 only. The state's elected to proceed on count one only. It alleges you committed the state jail felony offense of theft of property with 2 or more previous convictions from January 10th of 2023. The indictment alleges you were previously convicted of theft March 8th of 2000 and then again July 15th of 2016. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? Answer out loud.
Yes, ma'am.
And cause number 23 DCCR 0521, you're also charged with theft of property with 2 or more previous convictions from this one from January 11th of 2023. It alleges those same 2 prior offenses. And how do you plead to that charge?
Guilty.
And are those prior offenses true?
Yes, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
Did I print one? Just want to make sure I don't do it twice. Okay. And then in cause number 23 DCCR 0520, you're also charged with theft in count one only of property with 2 or more previous convictions from January 17th of 2023. It alleges those same 2 prior theft convictions. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
In all 3 of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in those 3 cases.
No objection.
It's admitted in each of those cases. Is there any evidence that Ms. Spooner is not competent?
No, Your Honor.
All right, Ms. Spooner, in each of these cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and that you understand the nature and the consequences of your plea. And cause number 23 DCCR 0522, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions, sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23 DCCR 0521 also finds sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions, sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23 DCCR 0520 also finds sufficient evidence to find you guilty, and at this time find you guilty of theft of property with 2 previous convictions, sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 27651 and 27, they have the same.
7651 26858.
There are first amended and two
There's first
six
amended in each, Judge.
in both. I need the first amended printed out in 26858, please. I'm gonna have to mark on it. We'll get it. real quick.
With your permission, Judge, we can proceed only on counts 2, 7, and 8. Those are the new offenses
Okay.
on each count.
Thank you. Thank you. In cause number 26858 and 27651, I have first amended motions to revoke your community supervision. It shows in each of those cases that you were placed on probation October 30th of 2017 for the offense of driving while intoxicated in each of those, and that was a 10-year term that was probated for 10 years. Is that correct?
Yes, ma'am.
1, 2, and 7.
2, 7, and 8.
The state is elected to go forward on counts 2, 7, and 8 in each of those cases. Count 2 in each case alleges that you committed the new offense of theft, a state jail felony, January 11th, 2023 in Jefferson County, Texas. And is that true or not true?
It's true.
Count 7 in each case alleges that you committed the offense of theft with previous convictions, January 17th of 2023 in Jefferson County, Texas. Is that true or not true?
It's true.
And then count 8 in each case alleges that you committed the new offense of theft of property, January 10th of 2023. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 7, and 8 in each of these cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you also go over them with Ms. Holmes?
I did. Yes, ma'am.
And do you understand them as well?
Yes, ma'am.
And you understand if I follow these agreements, you will also be waiving your right to appeal.
Yes, ma'am.
State tenders number 1 in each of these cases.
No objection.
It's admitted in each case. Ms. Spooner, in each of these cases, I'm going to find that you entered your pleas of true to counts 2, 7, and 8 freely and voluntarily. Find those counts true. And cause number 27651, find sufficient evidence to revoke your probation. And at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26858, also find sufficient evidence to revoke your probation. And at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these cases will run concurrently, which means together at the same time. In each of these cases, I'm handing you the trial court certifications that shows they were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. All right, good luck to you, ma'am. You can go back with the bailiff.
Yes, ma'am. Thank you.
Clause number 23, DCCR 0552 on Aaron Bergeron.
Yeah, and I'm going to ask for more time on Mr. Bergeron. He's not quite understanding
Okay,
everything.
okay. I will just do a normal reset on Aaron Bergeron. You're welcome.